Blog Talk Radio.
Chapter 1, The Dawn of the Guardian. Title: The Genesis of the Trust Guardian and the Birth of AI. In the heart of the bustling city, nestled among a forest of towering skyscrapers, a young man named BidZiil Bey found himself in the epicenter of the financial world. His office, dimly lit by the city's ambient glow, was a testament to the complex world he was about to navigate. Strewn across his desk were a myriad of financial reports, legal documents, and trust agreements, each one a piece of the intricate puzzle of trust administration and compliance. BidZiil was not just any young man. He was a legal prodigy, fresh out of law school, with a keen interest in the intersection of law, finance, and technology. His journey was just beginning, a journey that would lead him deep into the labyrinthine world of trust law, a world filled with fiduciary duties, asset conveyances, and beneficiary rights. His mission was clear: to revolutionize the way trusts were administered. He envisioned a future where the complexities of trust law could be simplified, where compliance could be ensured with the click of a button, and where transparency was not just a goal, but a reality. This was the genesis of the Trust Guardian, a concept that would merge the legal expertise of a trust officer with the efficiency and precision of artificial intelligence. It was a bold idea, one that would challenge the status quo and transform the industry. The birth of the syntactical trust was the first step in this journey. This innovative approach to trust administration harnessed the power of AI to streamline processes, enhance transparency, and strengthen compliance. It was a game changer, a tool that would redefine the way trusts were managed. As BidZiil delved deeper into the world of trust law, he began to understand the true potential of the syntactical trust. It was not just a tool, it was a paradigm shift, a new way of thinking about trust administration. And it was just the beginning.
Ensures a swift resolution relative to traditional legal procedures. The foundations, common law and contracts. To grasp the essence of common law arbitration, one must recognize that contracts underpin the entirety of this subject. A cornerstone of comprehension is understanding that every facet of life is governed by contracts. This overarching principle harmonizes with the concept that once a comprehensive understanding of contracts is achieved, individuals can more effectively navigate complex legal scenarios. Challenges within modern legal arenas. The reality paints a stark picture. Conventional legal proceedings often yield unfavorable outcomes. Statistics reveal a staggering 98% likelihood of losing cases in public courts. Concerning phenomenon necessitates a critical analysis of the root causes, leading to an exploration of how to transcend these challenges. A paradigm shift, exploring common law arbitration. The crux of the matter lies in departing from traditional courts and embracing a new paradigm, common law arbitration. This alternative approach is not confined to a mere concept. It holds the potential to secure freedom even for those facing incarceration. Surpassing conventional wisdom, common law arbitration challenges the notion that incarceration marks the end of one's legal options. The key to sovereignty, subject matter jurisdiction. Central to the understanding of common law arbitration is the principle of subject matter jurisdiction. Diving deep into this territory, the exploration reveals that Congress wields power over matters falling under the realm of international or interstate commerce. The breadth of these definitions practically encompasses all aspects of human activity, rendering sovereignty claims futile when pitted against congressional authority. Unveiling the thread. Congressional regulations. A key document, 27 CFR 72.11, offers insights into how individuals are drawn into the realm of congressional authority. The extensive list of terms encompassing ATF officers, commercial crimes, and jurisdiction-determining factors underscores the pervasive influence of these regulations. Even seemingly unrelated matters, such as DUI charges, can be drawn into the web of interstate commerce through the involvement of vehicles. The crucial role of commercial crimes. At the heart of this intricate web lie commercial crimes, a focal point determining the jurisdiction of courts. Crimes against revenue laws, burglary, counterfeiting, and a host of other offenses inherently linked to commerce fall under this category. The connection between criminal charges and commercial jurisdiction underscores the complexity of legal landscapes individuals unwittingly find themselves navigating. The emergence of arbitration. Arbitration, a quintessential aspect of common law, emerges as a beacon of hope for those ensnared in legal complexities. Legal oversight plagues the majority. Neglecting arbitration procedures can yield dire procedural consequences. The failure to raise this essential aspect within a case perpetuates the cycle of challenges faced by the majority. Empowering legal strategy, the path forward. Embracing common law arbitration requires a strategic approach, especially in cases with severe consequences like imprisonment. The nexus between arbitration and criminal cases, particularly those with the potential for jail time, holds immense promise. A crucial tool in this journey is the conditional acceptance notice, a new facet that enhances the arsenal of legal strategies. Conclusion. In the pursuit of justice, common law arbitration stands as an invaluable ally. As its reach expands and its mechanisms become clearer, individuals gain the tools to transform their legal outcomes. By navigating the intricate web of contracts, congressional authority, and commercial crimes, a path to sovereignty emerges.
I don't think any of you probably had a
The
contract.
once elusive concept of common law arbitration unravels as an avenue of empowerment, promising a brighter future for those treading through complex legal terrains. Unveiling the power of common law arbitration, a practical guide. Introduction. In the realm of legal complexities, the concept of common law arbitration emerges as a potent tool. Grounded in due process, this approach presents an alternative path to resolving intricate disputes. This article delves into the principles and strategies behind common law arbitration, revealing how it can shift the dynamics of legal battles. Challenging jurisdiction, the initial steps. To venture into the world of common law arbitration, understanding the delicate balance between jurisdiction and due process is crucial. When due process is violated, the right to challenge jurisdiction arises. However, this is not a mere challenge, it necessitates substantiating that the court has lost its authority due to the breach of due process. Unveiling jurisdiction, the commerce connection. Central to understanding jurisdiction lies the concept of commerce. Congressional authority extends to matters connected with interstate or international commerce. This expansive reach is the key to courts establishing jurisdiction. It becomes essential to challenge this jurisdiction if one is not engaged in activities falling under these categories. Utilizing conditional acceptance, crafting the path to arbitration. The heart of the common law arbitration strategy lies in conditional acceptance. This intricate process involves sending a conditional acceptance offer that, when not denied, transforms into a contract. This contract, based on the acceptance of various laws and facts, serves as the foundation for arbitration. Revisiting contracts, a shift in legal paradigm. The strategy takes a unique twist when dealing with mortgage foreclosures and related matters. Instead of contesting the validity of their contracts, a new approach emerges. The focus shifts to recontracting through conditional acceptance, effectively removing the debate from public courts and placing it into the realm of common law arbitration. The power of Matthew 18, navigating dispute resolution. The wisdom of Matthew 18 verses 15 to 17 offers a framework for dispute resolution that aligns remarkably well with common law arbitration, communication and resolution at a personal level before escalating the matter. The concepts laid out in these verses seamlessly integrate with the arbitration strategy. The role of arbitrators, the final step. Once the conditional acceptance offer is presented and a new contract is established, the process culminates in arbitration. An arbitrator, an impartial third party, reviews the documentation and certifies the existence of the contract. While the arbitrator does not determine the merits of the arguments, their certification elevates the contract's validity. Seizing the offensive, resolving matters with resolution. By establishing the contract through common law arbitration, individuals gain a distinct advantage. The court's jurisdiction is challenged, and a resolved contract is presented. This offensive move shifts the dynamics from defense to offense, placing the individual in a more empowered position. Conclusion. The world of common law arbitration is a realm of strategic maneuvers and procedural prowess. Through conditional acceptance, dictional challenges, and the wisdom of age-old principles, a path emerges for individuals facing complex legal scenarios. This holistic approach transforms the legal landscape, empowering individuals to navigate disputes with a new level of confidence and understanding. Decoding the power of conditional acceptance and common law arbitration. Introduction. In the intricate maze of legal proceedings, a beacon of light emerges, the realm of conditional acceptance and common law arbitration. These two strategies have the potential to transform how we navigate legal disputes, placing power and control back into the hands of individuals. This article embarks on a journey to unravel the significance and practicality of these approaches. The essence of binding and loosing. Embedded within the wisdom of ancient texts lies a profound principle, the power of binding and loosing. This principle, encapsulated in verses from spiritual teachings, reveals an interesting correlation with contractual agreements. By binding a matter on earth, individuals invoke a promise of future performance, essentially a contract. Conversely, loosing a matter reflects the consequences of one's actions, echoing the intertwined nature of legality and spirituality. Finding unity in resolution. The concept of unity finds its way into these teachings. The idea that when two or three individuals come together, they can achieve resolutions beyond their individual capacities. This unity aligns seamlessly with the essence of common law arbitration, a collective effort to find solutions through a process that transcends conventional legal battles. The missing link, arbitration and criminal matters. Delving into the intricacies of arbitration, we uncover its applicability even in criminal matters. The intricate web of law and commerce intertwines, with Congress reserving the authority to authorize commercial acts related to interstate commerce. This opens a door to arbitration in scenarios we might have overlooked, creating a unique avenue for resolution. The conditional acceptance paradigm. Conditional acceptance emerges as a potent tool in this process. It involves crafting a conditional acceptance offer that, when not denied, evolves into a binding contract. This contract is a synthesis of various laws, creating a foundation for arbitration. By embracing this approach, individuals initiate a sequence of events that empowers them and challenges the jurisdiction of conventional courts. Zeroing the account, a bold move. A critical juncture in this strategy is the act of zeroing the account. This involves leveraging offset credits to settle the account. These credits, often established when the contract is initiated, hold the key to resolving disputes. By invoking this mechanism, individuals take control of their financial narrative and pave the way for arbitration. Unveiling the prepaid nature of debt. The financial landscape is intertwined with the concept of prepaid obligations. The act of signing contracts essentially creates a prepayment for future promises. Understanding this dynamic empowers individuals to navigate financial scenarios with a newfound awareness, seeing through the complexities of debt and its implications. Building bridges with conditional acceptance. The essence of conditional acceptance lies in building bridges. By engaging in this process, individuals construct a new contract that challenges the legitimacy of existing contracts. This action is not merely about defying norms, it's about reclaiming control, demanding transparency, and invoking arbitration to find resolution. Embracing the 13th and 14th Amendments. Drawing from constitutional principles, the 13th and 14th Amendments play a pivotal role. The 13th Amendment's prohibition of involuntary servitude aligns with the idea of binding oneself willingly. Additionally, the 14th Amendment asserts the jurisdiction of Congress, a jurisdiction that can be harnessed to invoke arbitration and challenge conventional legal proceedings. Conclusion. In the intricate dance of legality and spirituality, the power of conditional acceptance and common law arbitration stands tall. These strategies offer a transformative approach to resolving disputes, shifting the focus from mere legal battles to a collective endeavor for unity and justice. As we delve deeper into this realm, the intricacies of binding, loosing, and constructing contracts reveal a pathway that empowers individuals to navigate complex legal scenarios with renewed confidence and strategic acumen. Mastering conditional acceptance and unveiling the power of arbitration. Introduction. In the intricate labyrinth of legal intricacies, a revolutionary approach emerges, harnessing the power of conditional acceptance and common law arbitration. This article delves into the depths of these strategies, unlocking their potential to reshape legal dynamics and empower individuals in unprecedented ways. Challenging the unbreakable chains. There is a whisper in the winds of legality that you cannot be forced into contracts against your will. This sentiment, though seemingly distant, is intricately linked to the world of commerce, where a subtle understanding of crime as a commercial offense intertwines. In a surprising turn of events, 27 CFR 7211 unveils a different facet of crime, positioning it as a commercial transgression. Constitutional footprints, 13th and 14th Amendments. The Constitution, a cornerstone of the legal system, takes center stage. The 13th Amendment serves as a powerful tool, granting Congress the authority to enforce its clauses through appropriate legislation. This authority gives birth to Article 9, a legal artifact that will be unraveled further. Meanwhile, the 14th Amendment stands as a guardian of privileges and immunities, showcasing the importance of contracts in this intricate legal dance. Commerce Clause, gateway to complex jurisdictions. Article 1, Section 8, Clause 3 of the U.S. Constitution introduces us to the Commerce Clause, a concept of profound significance. The Commerce Clause, Congress's power to regulate commerce, not only among states but also beyond national boundaries. This clause holds the key to understanding the interplay between commerce, contractual relations, and jurisdiction. Navigating the maze, utilizing commercial power. The intricate balance of power between federal governments and states is a persistent battleground. Congress has often employed the Commerce Clause to navigate this precarious terrain. By understanding its implications, individuals can use their adversaries' weapons to their advantage. This strategy is rooted in the concept of using commercial power against those who wield it. Conditional acceptance, crafting a new reality. Conditional acceptance emerges as a linchpin in this legal evolution. Its essence lies in constructing a conditional acceptance offer, evolving into a binding contract when not refuted. This novel contract is a manifestation of various laws, forming the bedrock for the ensuing arbitration process. Through this approach, individuals embark on a transformative journey, asserting their authority and challenging conventional court jurisdiction. Zeroing the account, a calculated move. A crucial pivot arrives when the account is /zeroed. This involves leveraging offset credits to settle the account, a strategic move that empowers individuals to control their financial narrative. This process unravels the mechanics of accounting, positioning individuals to navigate the intricacies of debt and settlement. Unveiling the prepaid nature of debt. Delving into the realms of debt, a profound realization surfaces the notion of prepaid obligations. The signature on a contract signifies a prepayment for future commitments. This shift in perspective empowers individuals to traverse financial landscapes with renewed clarity, unraveling the complexities of debt's dynamics. Utilizing the 14th Amendment's shield. The 14th Amendment, a cornerstone of equal protection, holds relevance in this legal journey. It shields individuals from the abridgment of privileges and immunities. Through this prism, the concept of contract emerges as a vehicle for asserting one's rights, paving the way for arbitration and justice. Harnessing international dynamics, UN and Congress. Venturing into the realm of international dynamics, the UN's role and Congress's acknowledgement come to light. The intersection of arbitration, international trade, and commerce adds depth to this evolving legal landscape. This acknowledgement underscores the importance of arbitration agreements in shaping a new reality. Conclusion. As we traverse this intricate legal landscape, the fusion of conditional acceptance and common law arbitration stands as a beacon of hope. By unraveling the essence of contracts, jurisdiction, and commerce, individuals gain a newfound understanding of their power. Through a systematic approach rooted in contractual mastery and strategic arbitration, individuals can navigate complex legal scenarios with confidence, challenging the conventional norms and carving out a path to justice and autonomy. Empowering legal strategies, mastering conditional acceptance and effective arbitration. Introduction. Within the intricate tapestry of legal intricacies, a new era is dawning, a time of leveraging conditional acceptance and common law arbitration to shape the legal landscape. In this article, we delve into these strategies, unveiling their potential to reshape legal dynamics and empower individuals in unprecedented ways. The enigma of courts, preparing the ground. A fundamental question arises: why would a court continue to preside over a matter that's already resolved? This paradox unveils a powerful insight. Our position in the legal arena revolves around discussing our contracts rather than focusing on the problems presented by the opposing party. By mastering this perspective, we gain an upper hand, shifting the power dynamics. The Genesis, Matthew 18 verse 16. The journey to the private side of the court, an elusive concept for years, suddenly gains clarity. Matthew 18 verse 16 becomes our North Star. It unveils a pivotal strategy: crafting contracts and having them privately arbitrated. This approach puts us on the front foot, offering a transformative tool to assert authority and challenge conventional court jurisdiction. The dance of commerce and contracts. Navigating the realm of commerce, we find ourselves at the crossroads of jurisdiction and contractual relations. A fundamental shift occurs as we realize the power of contracts in shaping the course of legal battles. By understanding the essence of commerce, we set the stage to utilize the legal system to our advantage. Conditional acceptance, a new reality takes shape. At the heart of this transformation lies conditional acceptance, an art that involves constructing conditional acceptance offers, which evolve into binding contracts when unrefuted. This revolutionary approach lays the groundwork for arbitration, enabling individuals to reclaim their autonomy and challenge traditional legal norms. Zeroing the account. A calculated move. The concept of /zeroing the account / emerges as a strategic move, where offset credits are used to settle financial matters. This approach reframes the understanding of debt and settlement, empowering individuals to take control of their financial narrative.
But this subject is common law arbitration, where common law, aka due process, actually happens. This is presented by urlaw.org, and you must be a premium member to get more of these details. As a matter of fact, you need to almost be a mortgage member or a member using the Slam Dunk program to first see this when we first release it. But over time, it's going to be available to more of our members as we put more test cases out. We can't take on everyone at one time, but we can take a few cases that are running right now and put this in, because it's a very quick process relative to other processes. Now, I want to stress that if you've watched some of the videos we've put out over the years about common law, subrogation, bonds, all that, well, guess what? It all is relevant to this subject, because the reality is everything is contract. And you're going to see some examples of that here in just a minute. But everything is contract. And so once you get it to that objective level of understanding, you'll have a more effective way to deal with what's happening. You're being pulled into a contract arrangements. And so I'm just going to go through this document. It's about a 5-page document. There's much more to go through. This actual document is much closer to about 80 pages, but I'm just covering the overview tonight. And then with the additional videos that we're going to do, it's going to cover more of the material. It's not very hard. It's really a very simple process. But if you don't understand the background of it and you're asking me questions, hey, well, what do I do next? What do I do next? Then I know that you already should know the answer to that, because we'll have already given you those steps, and you have to follow through. We cannot be here to answer all your questions. It's not possible for me to do that. So I want to be sure we give you a good, thorough understanding tonight in this video. And then as we release additional videos and the materials, and you read those materials, then and only then will I listen to questions. Because if you can't already answer the question, we haven't done a good job of putting it together. This is going to become self-explanatory once you get the concept. So tonight my goal is only to give you that big picture. But here's the bottom line. Most of us lose when we go into their public courts. It's about a 98% chance of losing. I don't know if you know those are the odds against you. Okay, so it's not good. Why is that? Well, I'm going to explain it, and I think it has to do with us violating a basic law of, well, really commerce. And so our goal is to move out of their public courts and disputes and maybe even get out of jail. As a matter of fact, so far it's proven that this process could get someone out of jail if you follow through correctly. Now, normally I would tell people once you've gone to jail, your chances are really, really slim. But here's the key. There's a rule in law that says subject matter jurisdiction can be challenged at any time, even after conviction, making it void. That's why we have a void judgment course. But this is going to help you do even that strategy better. So pay close attention. But if you're facing a criminal charge, this is even more effective. If you're dealing with a mortgage, it's perhaps in foreclosure or facing foreclosure, and you're either a judicial case or a non-judicial case, we're going to give you some ideas here as to what you can do. Those of you who are in our mortgage class are going to go through much more detail on this next week on that training. We're going to go into specific details how to do a mortgage if you're in that class. That's a special enrollment in addition to the premium membership. Details are on the premium member page. But the bottom line is you're dealing with foreign parties and you're falling under congressional rules or jurisdiction. And they, if you understand Congress, they don't regulate you and I unless the matter falls under international or interstate commerce. And what they've done is they've written a set of laws that are so broad that they almost all fall under interstate commerce. We wonder, people make a lot of sovereign arguments that, oh, my God, you can't touch me because this, that, and the other thing. However, if they can pull you in under international interstate commerce laws, they can. What we have to do is point out to them that we understand the rules of the game. And this is the nexus. This is something that so many people have missed when they fall into these courts. They say, I want my common law jurisdiction. I'm going to convert the court to a common law court. That is not a realistic way to look at this. But you can notify the court that you understand that you're dealing with a commercial matter at all times, even if it's so-called criminal. If you don't believe me, let's just open up this little link right here to 27 CFR 72.11. And I think it's going to become self-evident what's going on, how they pull you into congressional authority, even though you can say you're a state citizen all day long. You can say I have a passport that's a state citizen passport, or all these sort of things. They might help you, but if your activity brings you under this jurisdiction, you're under it. That's why it's so hard to get out from underneath. But I'm going to show you a way to fix it. But if you look at meanings of terms under 7211, 27 CFR 7211, as used in this part, unless the context otherwise requires, terms shall have this meanings described in this section. Okay, I'm going to skip this part. But what they talk about here is what falls under these terms fall under this jurisdiction: ATF officer, appraised value, carrier, and by the way, that's vessel, vehicle. Anybody even accused of traveling with a motor vehicle and driving under the influence? That's because, and if they get you into their court system, and even if it's a state court, they're pulling you in under the Interstate Commerce Clause. Okay, and let's go here because they don't clearly define what a vehicle is here, but they sure seem to think your car is one. But here's the big one: commercial crimes. Any of the following types of crimes, federal or state. Okay, start there. Offenses against the revenue laws. Ooh, you're offensive. Burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sale of property of deadly weapons, prostitution, including solicitation, pandering, white slaving. I don't know about black or brown slaving, if that counts now. That's old stuff. Keeping house of ill fame or like offenses. Extortion, swindling and confidence games, and attempts to commit, conspiring to commit, or compounding any of the foregoing crimes. Addiction to narcotic drugs and use of marijuana will be treated as if it were a commercial crime. Commercial crime. You guys want to memorize this term. If the word commercial crime falls into the conversation at any point, or directly or indirectly, this is how congressional authority and its laws affect you, even at the state level. But what if you're not engaged in any commercial activity? Or what if there is a commercial activity? You know what also has to go along with every commercial activity? A contract. And I don't think any of you have probably had a contract, many of you at least, to those issues. So A commercial crime requires jurisdiction and a contract. A truly criminal matter in the court must be an Article 3 court. And they don't give you that. The Constitution says it's a court of general jurisdiction. Now, versus being a commercial court of, sorry about the typos, this is just my notes, limited jurisdiction. And when they pull you into state court or U.S. courts, these are limited jurisdiction courts. It doesn't mean they don't have authority. It means they have limited jurisdiction. The limit is they can only deal with commercial matters. You think that, well, you know, DUI, how's that commercial? Well, because it involves a vehicle, which is a commercial thing. Got it? You have to see how these words pull you in. And it's not just your status that gets you out of these things. It's your activity and the lack of proof of activity. You already have your status. So all matters that end up in federal state court technically involve interstate commerce, which is how these congressionally approved courts gain jurisdiction. They do have jurisdiction up to a point, but they can lose it, and that's what we're going to focus on here. See, you've always had a right to arbitration to ask for it. Why? Because, well, I'll show you in a minute. I'm going to get to that in a minute, why that's important. So commercial courts must grant this right once raised. I bet you've never raised it. And we'll be able to show you in some of the more advanced training, we're going to show you court cases where the courts have said, oh, if there's an arbitration clause or if there's a matter that's still in dispute, like a commercial contract, and the contract is verified to be true, the courts lose jurisdiction. Don't you want them to lose jurisdiction at some point over you? Well, then you have to bring up the right matter the right way. So what happens is everyone skips over arbitration. But I can tell you, skipping over a step that should be part of the process, it will cause you all kinds of problems procedurally. And they're not going to tell you that it happened. They're just going to do it. And this is why I believe 98% of us lose our cases, because we skip from talking to our enemy to fighting with them.
Testing. All right. Now we get to the meat and potatoes of everything. Now we get to understand that, first off, trustee training, compliance officer training, there are a lot of moving pieces. And these pieces all hinge upon subject matter jurisdiction. All things that typically govern what you're dealing with have an arbitratable resolution. Because all things, even criminal offenses, they all start out commercial first. Your failure to establish that premise further inflicts the punishment that most experience. It's very difficult to go into their backyard and get a win. Hopefully you're taking notes. Let me explain to you how the session is going to go. We're going to go for approximately about 2 hours. Last hour, which will be the third hour, will be a Q&A. I will call your phone number by the last 4 digits, giving you an adequate time to ask your questions and get those questions answered. And again, I will give everybody, an opportunity to be heard. I know there's a lot of people that want to have questions, so I'm going to do my best to go to each and every person, give them an opportunity to ask their questions, because the only way I really comprehend whether or not you're getting this is the type of questions that I'm getting. And I don't expect anyone to hear this information for the first time and automatically have it. You got to at least listen to something at least 7 times before doing so. Which brings us to those of you that are in our BidZiil space have access to every class that we have done, because we post these classes in its entirety in our BidZiil in our BidZiil workspace. Those of you that are in Apex Capital, those of you that are in Diversity Holdings Limited, and then also those that are in Page, which is Private Attorney General Executors, all you guys have access to these classes. So please use this opportunity. Also on 365 Live, we also have continual content that covers civics, accounting, everything that we deal with, that we talk about. So there's never excuse for not having a resource to acquire information. And having that in conjunction with ChatGPT, I am under the impression that you have what you need. I'm just looking to assist with what's being done. Now, again, I don't want to have to tell everybody, you should do this, you should do that, especially if I arbitrated the case. I have to be very unbiased. I will give you notarial advice if you are a notary. I will give you instructions when it comes to M3 conveyances in compliance with current expected credit loss provisions. That's kind of a stretch for a lot of people, so make your questions relevant to that to get the information that you need. And we also have resource materials, which are also on our websites that you can purchase. So I'm under the impression that you have every fundamental tool imaginable to do what you came here to do. So I'm just simply here to give you these resources, give you the sources, source material, and constantly keep this in rotation so that you may build upon a platform or a level of knowledge that you have established. And again, if you need the one-on-one hand-holding, this, that, and so forth, I do provide that. I have a billable hour rate, starts out at about $75 to $200 an hour, so we can discuss that if that's what you need. But anyhow, those of you that are in compliance officer training, this information is impactful because 99% of the resolutions you're going to use when it comes to lending, when it comes to M3 conveyances, when it comes to acquisitions, are all going to be done through arbitration. But keep listening, because if you listen long enough, you will learn something.
And there's supposed to be, and is, and always has been, the right to arbitration. Again, I'm going to give you a historical reference, and there's more than I'm going to give you, but this is just one I'm going to give you in a minute. So here's what we're going to do. This is what I'm going to basically teach you, and then I'm going to give you a background for it. A criminal case where jail is a threat, okay? Not so much small traffic cases. I mean, a small element of this might apply, but really those where you're taking me from a civil traffic matter to, you assaulted the officer, or, you really didn't, but there was no real harm, but, or you DUI'd or something like that. You didn't cause a serious harm, although you might be endangering people, you still didn't cause that harm yet. Or if they're already in jail and going through a criminal trial now, this needs to include this new conditional acceptance notice that we're going to help you prepare. Those are in the slam dunk. I will be emailing you the link right away so you can start on this first as our test cases. And it's not going to be like you're a guinea pig. I mean, you're going to read it and go, well, this makes sense. I'm going to do this. It won't hurt anything. So anyway, we're indicating due process was violated. Once due process is violated, as we've taught you in our deficiencies training, then jurisdiction is essentially something you can challenge at that point. So you have to have a reason to challenge jurisdiction. They don't necessarily have it until you bring it up in the right context. You can't just say, I challenge jurisdiction, ha, ha, ha. No, you have to kind of show them that they've lost it. And therefore, whatever they're doing, whether they're trying to do it or they've already got a judgment, that it's void. Okay? Again, if somewhere in their documents they use any of those terms you saw listed at 27 CFR 7211, it's an interstate commerce matter. That's the only way they get jurisdiction. And you have to show them that, well, I'm not engaged in interstate commerce, so prove otherwise. And that's part of the process. There's literally a 400-point demand you give them. It's really well developed. So we're going to send them a new contract, okay? And we're going to develop the contract. And if they don't deny the contract, it is a true contract. And then arbitration is going to determine that the contract is valid. Once you have a valid contract, the court loses jurisdiction because it should be settled in arbitration then.
I think many of you caught that. When we do arbitration, we establish a contract. And a contract that goes through commerce unrebutted stands as fact. So when we listen to the facts and we present those facts through Uniform Commercial Code financing statements, and these statements are not rebutted in the form of an affidavit, they become fact. I want to make sure everybody understands that so I don't have to get into this repetitive, do you know who you are in the transaction? Because maybe I'm not doing it right. Maybe I'm just not a good teacher. Because if you know It's not what you say, it's what you do that determines who you are. If you're facing a foreclosure and they did all of these things and didn't substantiate anything, provided no documentation of the penalty of perjury, they didn't provide any of these things in the aspect of current expected credit loss provisions, and you're arguing, you're now giving merits to their argument in their jurisdiction. But if you establish a contract, in arbitration, we verified that a contract exists and it is valid. And these were the things that were used to settle the estate. Now you're able to utilize these tax forms, K-1 disbursements, M3 conveyances to do your bidding. Only when you have that mental concept locked down, now you're not waiting for magic paperwork, magic document. I always tell compliance officers / civil law notaries, when you look over the existing contract and you don't see a proper arbitration clause, that is your green light to be the change you want to see. But it amazes me that everybody waits for BidZiil to them, like, okay, write it up and then I'll push it. So I'm going to take a stab at it this way. Your first notary and second notary can't create documents, but they can authenticate, they can verify, they can utilize a notary protest to merit lawful legal money being used to settle the dispute, as long as they're witnessing and attesting to fact. So you can't bring them no bull, no BS. But if they witness fact, they can substantiate fact, and then they can determine who gets what. Because in the public, there's a tax form for everything. Mr. Bey, can I buy a car? There's a tax form for that. Mr. Bey, can I acquire real estate? There's a tax form for that. Mr. Bey, Mr. Bey, Mr. Bey, there's a tax form for that. You don't know what the tax form is, so that's where your studying needs to be pushed. Mr. Bey, which tax form should I use to acquire this real estate? Very good, grasshopper. Now we can get into 1098-Fs and things of that sort. But if we're going round and round about who are you in the transaction and the dope ain't yours and she hit me first, keep listening, because you just might learn something.
Well, might fight you in some cases, but generally speaking, they've got to follow their own rules. These are their rules. Mortgage foreclosures. All of these involve interstate commerce and thus require arbitration as to the contract in dispute first. Okay? Now, they usually don't do that. They just come after you and start going after your house, right? They either do a judicial process and sue you, or they do a non-judicial process and just try to take it. So we have to intervene and stop this. This is a much simpler way than even what we've been teaching in the mortgage class once you see how this lays out. Okay? But we want to make them cease and desist, bring it into a common law arbitration versus going through their public court system and losing the house, which is what's going to happen 99% of the time. Okay? Again, kind of falls under these commercial commerce clauses. This is the tricky language they've used on this. It's all commercial commerce matters. Therefore, Congress can create their rules and spread their rules outside the borders of the District of Columbia. Now, you can say it's not constitutional or whatever, but you understand the Constitution gives us essentially a right to contract, which means once they extend the contract and you don't stop the contract, then they do get jurisdiction. Contracts are the supreme law. Okay? So you do get pulled into these things, but there's a way out recontracting. We're going to show you how it's done here. So remember, Congress writes the law. They're all commercial in nature. They can only regulate what's going on in the District of Columbia and interstate or international commerce. Again, the study material I'm going to give you has plenty of references on this. But for me, the big one is Matthew 18, verses 15 through 17, and actually through 20. You must know what these mean and what they were written for. It is a commercial instruction. Now, whether you're what type of Christian you are, however you interpret the Bible. I'm just here to tell you that these are laws, and they matter, and the courts recognize it, and it's where due process essentially. I don't know if it originated there, but it certainly was clarified there, whether you agree with that or not. It's there. And it's like gravity. If I pick up a pen and I drop it, it's going to hit the floor every time. It's a law, a natural law. And this process describes natural law, how matters should get resolved. And if you follow it, it works very well. But if you skip it or you break it, for some reason, we always lose. And I think that's why we're losing our cases, because we don't understand this. So we're going to get into a very practical way to do this. Is we have to learn to do what's called conditional acceptances. And I say it's a common law arbitration is the procedure. And again, that'll show itself here in a moment. But if you want to look at the source, and I'm going to try to give you sources for everything that we talk about. And again, in the training that we're going to do ongoing on this, we'll have even more links so you can do your own homework. You don't have to ask me. But it starts off, and I've got this was asked the U.S. Catholic bishops' version of the Bible, where they explain things a little bit more. You can get various versions out there, but to me, I like to go more to the original source, and they tend to have the more original versions. King James or this one are good versions to go with. You'll see that it says essentially the same thing. So this is again Matthew 18 and verse 15. If your brother sins against you, and they added the word against you for clarification, go and tell him his fault between you and him alone. If he listens to you, you have won over your brother. Ladies and gentlemen, that's called just talking to somebody and working it out. That's always the first thing, and so many people forget about that. That's the best remedy for most situations. Talk to them. Work something out. Okay? 16. This is the biggie. This is the one everybody goes right past. If he does not listen, take one or two others along with you, so that every fact may be established on testimony of 2 or 3 witnesses. Now, you could look at this different ways, but I'm telling you, if you procedurally skip this step and you go to court, they're always looking, they're going to ask you, have you exhausted administrative remedies? This is administrative remedies. Courts follow this. Why? Because it makes sense. It's just good due process. Whether you think the court's corrupt or not, they still tend to lean on the due process procedures. And if you don't get too far off in sovereign land and patriot land on them and simply just bring them down to the procedures they have to follow, they tend to comply. They follow commands. I learned a lot of this in the self-help lawsuit course that, you don't have to get off on some of those nonsense issues. Just simply focus on what they're supposed to follow and hold them accountable, and there are proper ways to do that. So it says, if he does not listen, take 1 or 2 others along with you, so that every fact may be established. When you're sending things through a certified mail or priority mail with confirmation of delivery, maybe even having a third party send it and receive the documents, they become a witness to what your efforts to communicate a process. Okay? And what we're going to do in this process is we're going to send them a conditional acceptance offer that becomes a contract if they default. It becomes a new contract. We're no longer debating their contract now. We're not debating anything. We're accepting everything as long as they can prove that it still applies to us. After they look at everything, and by the way, these conditional acceptances are written in such a way that they're full of actual case laws and laws. In other words, they have to prove that it doesn't say that, we know it does. And therefore, it releases us from liability. And therefore, that becomes the contract. Hope you get that. We send them a conditional acceptance of all these various laws and rulings and facts that they're compelled to pay attention to. And if they cannot dispute what we know is actually true, then they agree that then they have no jurisdiction authority in our matter and should release and cease and desist or whatever it is they're trying to do.
A lot of individuals hope you're getting this. Now, let me give you, for those of you students who are taking notes, refresher. Write it down, go to your chat GPT, and do a complete, detailed, robust outline on CFR 75 11. And while you're at it, also do a detailed, robust outline of CFR 2711. So you have 7511 and 2711. Now, 7511 gives you the ability to arbitrate all commercial matters. CFR 2711 lets you prosecute violators of your Article 9 security interest. And let me explain it. CFR 2711 is the reason why public officials, corporations, and entities must be bonded and insured to operate in the public, because none of these individuals can make unbonded statements or declarations. So they got to be bonded in order for them to declare something. And anyone who fails to provide you their private their public bonding insurance information has committed fraud. Fraud is a failure to disclose. And someone has actually gotten something out of ill will. And all violators that you catch violating CFR 2711 can be forced into involuntary bankruptcy. That's why you're able to put UCC 1s, 3s on them, and then you can utilize the 5 to move that energy from the private to the public. The letters of credit are written off of UCC 5s, but you got to have all these things as the foundation. What happens if you are dealing with a case and you have arbitrated the case privately, but for some reason the public just won't stop? Well, typically they won't stop because it's not costing them anything. When it starts costing them money, and when you've gotten the Attorney General involved, when you got the Internal Revenue Service involved, when you got the Secretary of State involved, and you tie everybody up to each other with your documentation, this is why they always almost do some sort of seance to get you to emotionally feel compelled to drop your UCC, which to me is a blatant play on your intelligence. Since you say you got all the power, why don't you just terminate my UCC? Because they can't. Only the creditor can terminate the UCC. And they don't tell you that you can schedule a hearing to determine the merits of the UCC, because that puts them in your court. If you as a notary were to summon a public official, threaten them with failure to appear, just like they threaten you when you don't come to court, you threaten to forfeit their bond, and they don't show, well, you got a hot little item that you can now leverage in commerce. And trust me, out of 397 cases and counting, I have not had one public official who ever dared show their face in arbitration. They've always forfeited their bonds. As civil law notaries, you're not allowed to give legal advice. But in this training, you are armed with enough fundamental information to be the change that you want to see. And yes, arbitration cases can be appealed. Riddle me this, Batman. Out of the 30-plus students that are in this graduating class, 5 of them have been with me more than 18 months. So we're going to say the notaries that have been with me over 18 months, in my opinion, should form the appeal committee. That means whatever you arbitrated prior to the loop that needs to be changed, amended, appealed, that's where you take it to. But you just can't hand them the documents and empty promises. You're going to have a whole lot of what? Substance. But it ain't hard when you know who you are in the transaction. CFR 7511 gives you the ability to arbitrate because it's a contract. And CFR 2711 lets you enforce those violators who've committed insurance fraud under Title 15 United States Code. Because, see, when you don't give me your insurance information, you're committing insurance fraud. And when you go to court and you don't do none of this stuff that I'm talking about, like arbitrate, you're committing tax fraud. And these are things that should be your musical chair music when you hear a case, when you're deciding on how to make an acquisition. Keep listening, because if you listen long enough, you'll learn something.
It's out of jail. Okay? And this is a process. This is essentially arbitration. Because at the end of sending these documents, you're going to go to an arbitrator. We'll show you how to find one. And they're going to review your process. So now you get another witness that has some sort of official stamp of arbitration that they can put on. They don't have to have a special license, but they have to be independent. And they give the certification that all this happened and that the contract, the new contract you created, exists. That's all they do. They don't determine the right or wrong of the arguments. They don't care about the facts of your case. They just want to know, did you send this document through? Did they essentially agree by their default? And they really have no choice, because how are they going to argue against what the law actually says? That's all we're asking them to do. Then you now have a new contract, a new agreement. All they're certifying is that, yes, there's a contract here. Now, there's a contract, and the matter is resolved. You cannot go to 17 if that's done first. Once you bring it in and you notify the court that it's already been resolved in arbitration, basically the court loses jurisdiction, because you're not giving it to them to resolve, because it is already resolved. And you're not going to them with this other matter. You're going to them with your new contract, a resolved contract. That's going on offense. We've talked about this so much, but this is a non-judicial way to establish an offensive move, if that makes sense. So if he refuses to listen to them, tell the church. And these days, what we're talking about here is the court, because churches were a place where these things used to be heard. And if he refuses to listen even to the church, then treat him as you would a Gentile or a tax collector, okay? An outsider, somebody who's violating you, all right? And that's court. These rules.
Did you catch the scripture? If he refuses to listen to the church, then treat him like a Gentile or a tax collector. That's why there's a form for everything. This is why they have you swear in the Bible and all this stuff. But you don't understand the sciences. It's not my job to tell you what they already know. My job is to keep you safe, because you're on my watch. And while you're on my watch, I'm going to tell you unequivocally the preferred position that you will not have to worry about public obligations. Intrastate and interstate commerce is how they rope you into these things federally and on a state level. Because it's your actions in commerce that has everything to do with accounting. Now, a lot of people want to do these things and not give a darn about accounting. And I say, well, why hang up a painting with a shoe when you got a perfectly good hammer in the toolbox? Because if it's accounting, then you can call the case. I'll give you an example, and this is not legal advice. I'm just having a conversation. They can accuse you of doing this particular action that was deemed illegal. And you can ask the question. So just so we're clear, are you stating that this particular action that you have deemed illegal is actually non-taxable? That's a proper rebuttal. Creditors ask questions. It puts your claim back on top. And now we're talking about accounting. Well, you did this, and this is considered illegal. So just so we're clear, are you saying that what I am being accused of, is this a non-taxable offense? Now, if you don't understand why I'm rebutting this way, you need to do some more studying. Because your remedy is in your pocket that you refuse to use. Mr. Bey, what tax form should I be using if it's going to be a commercial matter, but it started publicly on their side of the fence? Well, there's many different forms, but I'm going to give you called Form 1098F, as in Frank. 1098F, as in Frank. That's not the only form, but that's the form that pushes what you did in arbitration to someone else's book or ledger. Now, at this moment, when you take value and put on a 1098F, everything you do is really extra. It's extra. You're just doing this because you have some sort of moral compass. You're trying to make sure it's extra. All you are required to do is settle and close and disperse a K-1, corporations or entities that are bonded and insured, and balance the book with a 1098F. 1098F, it settled and closed the DTCC. The 1098F moves value through the DTC. The 10K moves it through the DTCC. Yeah, that's better. I think they'll get it if I say it that way. I repeat, when you want to put things into the DTC, you will use a 1098F. When you want to move things into the DTCC, then you will use a K1 or K2 or a K3. We haven't talked about K2s and K3s. We have talked about it in our advanced classes, but most of you guys are in the beginning stages, so we'll just keep it at K1s. I hope this is starting to make sense to you. I hope you're writing your questions down. I hope you're taking notes. I'm going to give you some more fundamentals. The word legal means taxable. The word illegal is synonymous with non-taxable. The word fraud is a failure to disclose. So when they say you committed fraud, you ought to rephrase, do you mean there was a failure to disclose? Because I did list this information on the UCC1 and the UCC3. So how was that failure to disclose, Your Honor? See, all crimes that are reported by plaintiffs are commercial. Every public official must, upon request, produce their public hazard bond insurance information. Failure to disclose constitutes insurance fraud under Title 15 United States Code. Public officers are in violation of CFR when they do not provide their bonding and insurance information. They are in violation of CFR 2711. And all violators of CFR 2711 can be forced into involuntary bankruptcy. You get to put them in involuntary bankruptcy when they don't provide their insurance information under CFR 2711. And how you get your case back on top and arbitrate it privately is you literally say something, and don't repeat myself. Don't repeat what I'm saying. Just listen. Design your own. Be original. Is that this blah, blah, blah is in direct violation of CFR 5711. 5711. You're in violation of that. Well, no, it's 75-11. There we go. So let's back up. You let them know that their inability, they have not, quote unquote, done things a certain type way. So we need to handle this through arbitration, and it is CFR 75-11 that gives you the ability to arbitrate. So please understand these things. Ask questions according to where you are and who you are in the transaction, and I promise you'll get a whole lot more for your money. Hopefully you're learning something. Somebody give me a heads up, thumbs up that my audio is coming in loud and clear and that everybody can hear me. Somebody send me a text, something. Let me know that my audio is coming in loud and clear. And again, I want to give everybody a chance to ask their questions. In the last hour, if you get dropped out of this thing for whatever reason, for some reason, Blog Talk will not let you come back in when we get into the last hour. We got about 53 more minutes left before we go into the final hour questioning. So keep that in mind. Do what you got to do so you don't be left out in the cold wanting to ask your question and you can't because you've been booted out the system. Hopefully you guys are getting this. Hopefully this is making sense. Matter of fact, I'm going to go ahead and start some questions early because I'm curious to see who's really listening. Again, I'm going to call the last 4 digits of your phone number. Give you an opportunity to ask any questions based on what we've covered up until this point. Caller, last 4 digits of your number is going to be 9681. 9681. I'm checking in to see if you got any questions, comments, or concerns of anything you've heard up until this point. All right. I can hear you.
First, I want to go over the words you use for like non-tax, like you said legally that meant non-tax, and what you said illegally was taxable. Is that correct?
That's exactly. So I'm getting a lot of wind in the background. So just, I don't know if I can. There we go. Beautiful.
Okay.
All right.
Okay.
Go ahead. Repeat that. What you just said now.
I was trying to get my notes correct, and you said something like illegal meant taxable, and illegal meant non-taxable. Or do I have those? Right. Are those? Right. Do I have those backwards?
You have, all right, taxable. All right, so legal means taxable.
Okay.
Illegal means non-taxable.
Okay. And so, then I had, okay, go ahead.
So when they tell you you've done something illegal and you're a debtor, you're going to tuck your tail between your legs and bow down and do what you need to do. When you're a creditor, okay, you're going to respond with a question for clarity. So you're saying this is, if it's illegal, if it's illegal, for clarity, are you saying this is non-taxable? That's how a creditor responds with a question.
Okay. And then my other question was, they were talking about foreclosure, and how long is the window for foreclosure? Like if somebody lost their house.
Subject matter jurisdiction can be brought up at any time. Like if it was a criminal case, you already don't gone to prison. You can bring up subject matter jurisdiction even though you've already been convicted. You've already lost the property 5, 6, 10 years ago. You can raise subject matter jurisdiction and get back on top. No limitation when you're challenging subject matter jurisdiction.
Okay. So you saying that, and so they took a house, but it never came on the person's credit report as a foreclosure. So what tax forms, if I'm saying this correct, what forms could I be able to tell this person that they can use? Or should I just? Well, I guess it's better be yet for me to call you in your office to get you more details.
Call 407-792-2774, and after we have a consultation, they're probably gonna fill out something like a 1099-C and a 1096, and depends on what they tell me. There's forms for that.
Okay, and those were my questions.
Okay. Cool beans. Just hold what you got. See if I can make the rounds, man. See if I can make the rounds. All right. Let's go to caller. Last for because your number is going to be 7377. 7377. Can you hear me?
Greetings.
Greetings.
How are you today?
Pretty good. How about yourself?
Pretty good.
All right.
Okay, hold on. It's my notes. Okay. So you said Title 15 of the U.S. Code?
United States Code.
Of the United States Code, right, when they default from giving their information.
Correct.
Okay. We will cite CFR 2711, or excuse me, 7511 first as our arbitration rights. We need to cite a case in there. Okay.
Correct.
And then do a 2711 when they acquiesce, because they're right. Do a 2711 to request arbitration to provide the bond and insurance information. When they don't respond, they forfeit their bond.
Correct. The bond is forfeited. That will serve as part of the settlement. You can use it in any form or fashion you see fit to restore the estate.
Okay. When you were talking about challenging the subject
matter jurisdiction.
Subject matter jurisdiction, you can actually do that on cases that are, people are incarcerated right now, right?
Correct, Namundo.
Okay, but we have a situation with a particular client that has been probably charged a multitude of times, and on a harassment charge and violation of a restraining order to see his daughter. Okay. And the DA called yesterday and apologized because there was they had never had enough evidence for any of the charges.
Right. Okay.
So I said, hold on 1 second. Let me take it to the form.
Right.
So we could actually start the subject matter jurisdiction challenge for him on this particular case, correct?
Correct.
Okay. We'll bring it to arbitration.
That sounds like a plan.
Okay, thank you.
All righty. All right. Loving it. All right. Next caller, last four digits of the number is going to be 3722. 3722. Can you hear me?
How you doing, brother?
All right. What's good?
Everything is good, man.
All right.
Okay.
Talk to me, Big B.
Well, actually, Monique just answered part of my question as far as how they give up, how they forfeit their bonds. So I'm clear on that. My next question would be with the 1098F, since that's a tax form that goes into the DTC. So I guess my question is, that is something that we will add within our sandwich when we do arbitrations in order to be able to transfer. Correct?
Correct.
That's what. Okay. Right. That's what I wanted to get clear on, because I wasn't clear on exactly what the 1098F did.
Correct.
I appreciate it.
All righty. All right. Moving down the line. All right. Caller last for digits. Your number is going to be 5365. 5365. Can you hear me? Last 4 digits is 5365. Can you hear me? Going once. Going twice.
Can you hear me now?
Oh, hold on. I can hear you now. Let me bring you back, bro. I was just finna skip over you, man. I can hear you now. All right, talk to me now. I can hear you.
Okay. So so my question was now with the Freedom of Information Act,
right?
Is that something that you would suggest be done first before you even like that would be the first thing you want to do, get all the information pertaining to the freedom, like their bond information, and to gather all that information first?
That's a way to go. Yes. Like if I don't have no point of reference, and I'm doing gathering evidence for a preliminary hearing, then yes, I would probably pull a Freedom of Information Act if I already don't know where to go. But I'm gonna I'm gonna let you off the hook, and then I'm gonna put you back on another hook. If you understand that everything is commerce, the reason why you're going to the Freedom of Information Act is because you're trying to gather additional information and eventually cross this road. I'm going to give you a shortcut. Everything in commerce is a tax. That's your jurisdiction. So if I'm pulling anything on the Freedom of Information Act, I'm looking for where is this information that they've alleged and hedged in the ledger on the tax form. What do they file us with the IRS? They ain't done this with the IRS. It's considered not done.
So they basically getting you getting all of this, getting you all caught up in this one little area, and they ain't letting nobody else know what's going on.
Right.
So
and see, that's them. It's your job as a notary to correct the records. Literally, there are individuals walking around keeping an argument alive because they have faith and belief that what they're doing is working some sort of magic on the other end. When in fact, you're tethering yourself to a rock that's going to drown you. Because they told the IRS, they didn't steal anything from you. They didn't kidnap you on the street. Like if you was arrested, they said we didn't kidnap him. We gave him an opportunity to settle his debt. He didn't settle the debt. That's what they're saying. Hell, you know they kidnapped you, but that ain't what they told them. So even when you get out of jail and you're on probation, and you listen to this, there's a reason why they won't give you your gun rights back, but they hurry up and give you your voting right back. You got to figure that out. How is it that I can be a convicted felon, but I can vote, but I can't bear an arm?
Right.
They'll say, well, we didn't say that. Your actions merit that that's what we're supposed to do. If you are who you say you are, why in the hell are you trying to do this? You're supposed to put us on notice of what you've already done. But that's too real. You got to remember, the average high school graduate is literally a walking illiterate. And that's not to belittle no one. If you got a college degree, you're an illiterate. Especially if you speak English real good. and that goes over your head. If you're melanated and you speak real good English, all right. They know this. I know I got some more on the line, man. That's what happened to Freeman's Bureau. I mean, I'll go there in a different class, but there you go, brother. Any other questions?
No, that's all I have.
Okay. All right.
Okay.
Going down the line. Caller, last 4 digits of your number is going to be 9074. 9074. Checking in to see if you got any questions, comments, or concerns over anything you heard up until this point.
Yeah, I got a question.
Sure.
When dealing with, say, the 1098-F, what's the dollar amount? If I'm not familiar with the form, so I'm not sure. It almost got to ask for some type of dollar amount if it's a tax form, and if it say it was a court case.
It's going to ask you for a court case, a dollar amount, a judgment amount. Yeah.
So that's what we will put in there, the full amount or judgment amount.
when you say a 1098F, that deals with a lot of different types of cases, so that's a different type of math. So you got to give me some more intel for me to tell you what number goes where. I will say unequivocally that there should be some sort of accounting if you got a judgment, and that should be what you put on that form.
Okay. Right, I'm following you. Yeah, I got what you're saying.
Gotcha.
Another question: when demanding these public officials information, their bonding information, and then having to go through the FOIA and everything, if you're still unable to get it, what information do you then put on file in terms of creating the bankruptcy?
Okay. It's not that you didn't get it. You just didn't recognize what you was looking at. Now, I'm going to kind of say this where you should get this.
Okay.
Let's start out by examining what is insurance.
A bond, like an indemnity bond?
Oh, an indemnity bond. So if they got an indemnity bond, what 9-digit number signifies that there's some sort of bond in place?
Or it'd be the QSIP number?
Okay, QSIP number. Now, when we play the name game, y'all don't get lost because I'm finna bring them back to reality. QSIP number. Give me another 9-digit identifier besides the QSIP number.
A social is one.
EIN. Yes, EIN. So let's stop right there. If you went and you didn't find their bonding information, but you went and pulled a 10K on a publicly traded entity and see their tax ID number, you do got a policy number.
Okay, gotcha. So in essence, so if this was, I get it. When I run the whole play, yeah, that they got a blanket bond that's covering whatever public official that's underneath. Would that be correct? Oh, gotcha.
Correct.
Gotcha.
Correct.
Okay.
All right. Any other questions? They getting it. He getting it. You got any questions? Any more questions for me, big bro?
Nah, man, your short bus is catching up, man. The short bus is catching up. Bro.
I got you, big bro. Long business. All right, let's see. We're going to go down the line. We're going down the line. Last 4 digits of the number is going to be 0199. 0199. Checking in to see if you've got any questions, comments, or concerns of anything you heard up until this point.
My comment is I appreciate you as a teacher, and what you're teaching us is adamant. I think sometimes that the reason why certain people might not be catching on to certain things is because they may have missed certain classes or phrases. So rather than being new to the class, they're trying to just put the pieces together. But like the brother said, the slow bus catches up.
There you go.
So I was really kind of getting off into this new piece. There was something that you had on the recording yesterday from one of the radio broadcasts, which was about the Bailey-Baylor process and how to file at UCC. And now listening to this, I'm seeing how I really want to hear that broadcast again from the beginning, because he says something really powerful stuff at the beginning. But I'm seeing how like this whole thing kind of comes together as far as the different aspects of us as individuals and our status, and then our trust. Like they're all different components, but they all kind of form together like Voltron. So what I was looking at is the Tim Turner document. He has something in that section 1. I found one of my old ones, and what this gentleman is talking about applies to this. Like, we need to take that and reform that to fit this process, and then add the indemnification and the policy to that format. And now we have something that kind of makes us a little bit more, quote unquote, bulletproof, or that immediately takes us out of jurisdiction. Because even with that Bailey-Baylor situation, if you're placing yourself in the custody of your trust, they don't have jurisdiction anyway. So
exactly.
You know, so I'm people to play. I'm just trying to get all of the languages and the verbiages and the codes together. That's the part that needs to be tailored. But I do see it.
Right. That sounds like a plan. Well,
yeah, I didn't really have any questions. I wanted to know, as far as for the case study, where did I have to upload that at? I did everything else. I just need to know, where did I have to upload that last case study for the arbitration? Like, what part of the website was that?
Basically, if you've already filled out the forms, the website will populate a response, and it'll send you additional instructions and information. So all you got to do is interact with it. It'll go through its cycle, and then you should be receiving an email within 24 hours.
Okay, so just hold tight. I got you.
Right.
All right. That was it for right now.
All right. Sounds like a plan. All right. I'm loving it. Let's see who else. What kind of questions we got here. All right, caller, last 4 digits of your number is going to be 5116. 5116. I'm checking in to see if you got any questions, comments, or concerns of anything you heard up until this point.
Yeah, peace and love, Brother Biz. How are you?
Peace and love, big bro. Talk to me.
Okay, I didn't quite catch everything, but I'm quite sure that your broadcast is like very, very instructive and very educational. But what caught my ear was the insurance and the QSUP numbers, along with the Social Security numbers or EINs. That would create the insurance on bonded instruments. Could you expound on that? Can you get into a little deeper?
Okay. Yeah, I get into it.
As to how that insurance could benefit an individual.
Right. So let's talk about this without giving legal advice. I'm gonna give you notarial advice on the current expected credit loss provisions, and then they also have under IFRS 9. So I'm speaking of FASB 95, IFRS 9, and current expected credit loss provisions. So when one, such as a fiduciary, finds that an entity is in violation of Title 15 United States Code, and that violation is under CFR 2711, which is insurance fraud. When you enforce involuntary bankruptcy, in that documentation, you can exercise your right of indemnification, which gives you the ability to take whatever numbers and conveyances that are around and construct your very own indemnity bond and private insurance. Now, only under current expected credit loss provisions, IFRS 9 and FASB 95, can I directly say, once they have not provided their public hazard bond insurance, once they have violated CFR 2711 by committing insurance fraud, and because they are now in public court making unbonded statements, they're committing tax fraud. So you have to be isolated from all public obligations and liabilities when doing the admirable thing. Just because they didn't provide the information, that doesn't let you off the hook. That just means you get to reconvey that value. Did that make sense to you? Brother Calvin, that made sense to you, big bro?
Yes, it does. Yes, it does. As it relates to any type of conveyance that a person is that I may be trying to
Right.
I appreciate it, Brother Biz, and I'm gonna yield to your platform. Peace and love.
All righty, man. Peace and love, big bro. Peace and love. All right. We're going down the line. Okay. Caller, last 4 digits of your number is going to be 9895. 9895. I'm checking in to see if you got any questions, Comments or concerns or anything you heard up until this point?
Hey.
Greetings.
Greetings. I have a question about some procurement and contracts.
Okay.
Does adding arbitration strengthen a bid for a contract? Or I guess I'm kind of needing you to give me a quick overview of bidding with contracts and arbitration in regards to that, or if it even correlates. Yeah. Okay,
so when you're procuring a contract, there's definitely some strength in designing, and we'll use the legal sense, a provision to resolve disputes. Wherever that bid goes into how do we resolve disputes once we acquire the bid or we have the bid, perfect opportunity for you to implement an arbitration clause. Now, if you're looking at the bid itself and it doesn't have an arbitration clause, then it would be to your advantage to exploit or explore the opportunity to construct one. So yes, if I, quote unquote, was a potential contractor and they have a dispute clause, I'm all ears and I'm all in, because you're kind of saying this is a great contract to participate in, because look, we can agree to disagree and we have a forum for that. Now, without getting into the legalities, I will say that awards over $50 million, they come with an arbitration clause, and they really kind of dangle the carrot at a couple of their preferred carriers. You start hearing words like we have a preferred carrier. You know, if you're already part of this particular group of insurance members, then you'll be part of the preferred carrier plan. And under that, see, that's how they leverage the insurances. So definitely, I'd say it will definitely add value to any bid and contract.
So speaking on the insurance part, does that add any value, or is that?
Yes, ma'am. Yes, like you really need to
in a bid for a contract. Speaking to your insurance strengthens it.
Right. Pull them aside and be like, okay, I'm interested in acquiring this type of contract. What do you have in the a la carte or red carpet for that, or do you have a product that specifically protects me? You know, and so let them do what they do. Let the salesman sell you something that gives you, it incentivizes your ability to contract.
Okay, gotcha.
So definitely, that could definitely enhance that. Any other questions?
Perfect. Not right now. Thanks.
All righty. Moving down the line. All right. Caller, last 4 digits of your number is going to be 5387. 5387. I'm checking in to see if you got any questions, comments, or concerns of anything you heard up until this point.
Yeah, I got a question. So when you submit your conditional acceptance, you're going to add the affidavit of truth to that in reference to the conditional acceptance or being a part of the conditional acceptance?
The truth affidavit serves a lot of purposes, so it would make sense to include some sort of affidavit of truth to substantiate some type of some type of declaration or summary or declaration judgment of sorts. So if you have a judgment or a summary judgment, then a truth affidavit definitely makes sense to accompany that documentation.
Okay. As far as the 1098F,
right?
Can you break down the function of that? I'm kind of
okay.
I'm trying to see how does it add.
Yeah, without looking at the form, if when you look at the form, you'll be able to tell exactly what it's used for. So I'm going to say, for all intents and purposes, because nobody probably is looking at the form, when you look at the form, they're going to ask for very specific information about your case and the value of your case. And when you present that form to a potential fiduciary, they're able to monetize that form.
Okay.
Right.
So how do they monetize that form?
Do you understand debt securitization?
Yeah, partially.
Okay. So tell me what you understand about debt securitization, then I'm going to show you how they do that with the form. Explain in your own words how debt securitization works.
What happens is that whatever the debt or the secured interest is, they securitize it and then they sell it on the secondary market.
Okay. Now, what are they selling? Give me a name.
They're selling the future proceeds.
Future proceeds could future proceeds could be labeled as future value? Could this be considered unearned revenue? Could be potentially rights? Could this be general intangibles? Let's stop at general intangibles. These forms capture cases and put it into a general intangible receivable and payable. And any fiduciary that's bonded and insured that has an EIN number, that is a publicly traded institution, that has individuals that must be licensed and bonded to operate, must accept those type of credits and debits first before we get into public obligations and debt derivatives, because it is illegal. You're committing 15 felonies by creating debt derivatives because you're bartering and trading securities without a license. They don't take you to prison, they just tax you to death.
Oh, okay.
So these forms are what blue chip players play with. Gentlemen like Warren Buffett, who is worth, quote unquote, billions, he draws a pension from Social Security. And that boggles the mind of the average everyday citizen. He must, whenever he talks, he said, I must draw my pension from Social Security. And that's wisdom far beyond these walls of what we're talking about. So if someone who, quote unquote, has access to billions must draw a pension, what does that say about those that don't control?
They have to do the same thing. I don't know the reason why, but they have to do the same thing.
Right. You got to understand, the public is only a reflection of what's happening in the private. It's just everybody in the public's got to be bonded and insured. And if you're not asking for these sureties, like the average consumer, they hear us talk about gold and silver, but they don't give a rat's ass about gold and silver. They give a rat's ass about what gold and silver can get, what they can buy.
Yeah. Right.
And that's the problem, because wealth isn't the fiat. Hell, wealth isn't the gold or silver. Wealth is backed by resources. When you say you got $1 million, I'm going to say $1 million of what? If it ain't tied to a resource, it sounds like a liability to me. And then if I ask you, when you got that $1 million, you do a CTR and you start saying, well, what had happened was, I'm not going to run from you. I'm not going to turn my back either. I'm just going to moonwalk slowly. Because what you just beat on your chest and said, look at me, I'm a huge liability. You can't even call yourself a creditor if you don't convey consumer goods. Like when you start putting on the UCCs, you are a secured party creditor, you're going to learn this. The gatekeeper's going to say, well, okay, prove it. Where's your consumer goods that you're soliciting and selling to the consumers? And you're like, well, what had happened was, they're going to be like, man, nigga, quit playing. You bullshit. Now I know you crazy, you know. But that's a different class. Any other questions? Any other questions?
Not, as far as the insurance, you stated that the EIN can be the insurance identification number.
The EIN. Let me give you a short history lesson in the EIN. Corporations, legal entities, they have an EIN that stands for what? What does it stand for?
Employer identification number.
An employer identification number. That's also tethered to a TIN. What does a TIN stand for?
Tax identification number.
Okay, so when you are operating under the EIN/TIN office, when I present you lawful legal money, you get to come out from behind that EIN, utilize HR 192, and offset your public debt dollar for dollar against that negotiable instrument that's tethered to those premises. The EIN was the exemption for businesses to get out of being responsible for public obligations. That's what the number is for. Now, when you're doing everything else but offsetting public obligations with that number, are your books balanced or are they out of balance?
They're out of balance.
Now, when your books are out of balance, everybody who don't know this, you're going to know this today. If you start a business, they're going to give you 7 years to sink or swim. I'm going to say it like this. They're going to give you 7 years to figure it out. So if you borrow money, because every business has a right to borrow money and lend money, and you're not supposed to be just borrowing all over town and not lending. That's how you get balance. You're supposed to be borrowing and lending. Some people call it investing. I'm just giving you the facts. That EIN has a dual purpose. It's just the average consumer will get one. Like if you work a job and don't have an EIN, I say you're wasting time. What are you doing? That's just me. That's how I think. That's my swag. Don't do what I'm telling you. Just I'm trying to drive home a point. The EIN can be used as a QSIP. It can be used as a policy number because all those things are tethered to the purpose, the intent of the number. And when you're doing legal research and you can't, for some reason, find their private or public hazard bonding information, but you understand that they are bonded and insured in the public, someone said we can pull a Freedom of Information Act request. You can find a EIN number by doing a Freedom of Information Act. You have all the numbers, but when you don't know what to do with the numbers, because it's just like this. How do actual insurance companies pay on an insurance claim? You have any idea how that works?
Well, they have to register it.
All right, let's back up. What do if I have Aflac or I have Geico? Let's say, well, I got Geico. I got auto insurance. Somebody rear ends me in my Mercedes, right? And I got Geico full coverage insurance. How does Geico pay out if they have to pay out? If a claim is made on my insurance for whatever reason, even though the accident wasn't my fault, how does Geico pay out? Matter of fact, I'm going to make it real basic for you. Think about insurance claims just like you fill out a UCC-1. So when you get the accident, that's the UCC-1. When the check get cut, that's the UCC-3. Got it?
Mm-hmm. Okay.
The UCC-1 is going to show who's the creditor, who's the debtor, and the collateral that's involved. The UCC-3 is going to do the assignment, transfer, suspend, or terminate. And then the 5 once that information on the 1 and 3 is put on the 5, now you can draft a letter of credit. And there's a whole security settlement system for letters of credit. And there's something you can call a letter of credit where if you wrote one tonight, you can get funding tomorrow. But that's a different class. Any other questions?
Okay. No.
All right. Going down the line, and you guys got 13 minutes left. 13 minutes left. If you get dropped off after the 13 minutes, you will not be able to come back in. So I suggest charge up, power up. Do not fall off, because in the next 13 minutes, we're in the last hour. All right, now we're going down to call. The last 4 digits of your number is going to be 1945. 1945. I'm checking in to see if you got any questions, comments, or concerns over anything you heard up until this point.
Yes, sir.
All right. How are you?
Fine. How are you?
Pretty good.
Okay, I got a couple of questions that take quick answers.
Okay.
When you're doing an appeal, can you introduce a CR 27 or 7511?
Yes, you can.
Okay,
yes,
and that will be asking for the tax ID for the binding information and for arbitration.
Right, like you're challenging subject matter jurisdiction of the case. And so you can make your challenge under those provisions.
Okay, so you can. So can you request arbitration during the appeal? Considering that UCC1 is being ignored by the lower court?
You can, but requesting an arbitration by the appellate court is kind of like, let me give you, and I'm glad you asked this question. You would let them know that there is an arbitration already warranted you a judgment. This is why you did the UCC. Listen to how I'm saying this. What merited the UCC was arbitration. And if there was a default, the state would have notified me when that was filed, and when there would be no judgment certificate ever being issued if there was a problem with that. So now the appeal is going to tether. It's going to tie in the fact that there's a UCC that you completely ignored. So we're going to grant this case being appealed, and we're going to move out the way if she wants to pursue you legally for damages. See, the appellate court is going to acknowledge on the record their boo-boo. You just got to provide enough information, because that's all they're going to look at. You know, they're not going to roll the tape and listen to how nervous you was. They ain't going to do all that. All they're going to look at is black and white.
Okay.
So
now, can you use? Go ahead.
Go ahead.
Can you use FOIA when you're asking for title policy info?
Sure can.
Okay. And using ChatGPT to do the outline.
Right.
Okay.
Right. That'll help you with your framework. So use the ChatGPT as your legal assistant. Like when you're trying to draft documents, I'm gonna give you a free one because you asked that question. That's a good lead in. Assign a role to your ChatGPT as a legal assistant. Like, you are a legal assistant. Can you draft me blah 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 blah? Now you've given it the role and the freedom to act in that capacity. Or you can say, you are a lawyer. I'm working an appeal. Give me 5 reasons why you would deny such and such and such and such. It gets very interesting, and it sharpens you on what you're trying to do.
Okay. How would I ask for the CR 27 and the 7511 on the appeal form, in the appeal process?
Basically, you would literally, instead of asking, you would acknowledge the violation because I made a request last Friday. They failed to disclose their public hazard bond information. And it has been referred to me by many legal resources that all public officials must be bonded and insured to practice law. So either they're practicing law without a license. We know that to be true because I've never seen a license, but that's a different class. The other way is that you're wanting your appeal brief to state the obvious. The obvious is that they have not provided documentation. And if you cite one fact, let's go here. If you cite 20 facts and they only rebut 2, all you need is 1 for an appeal. I'm going to say cite more than 1 because if the sky is blue and they saying it's purple, well, they might not like the blue sky, but that doesn't make it blue, or purple rather. You follow me? State facts, they can't rebut them because they got to rebut them under the. They just can't say, well, that's not true. They got to put it in the form of an affidavit, point for point, and that's mission impossible. That's why I don't ever want. That's why I don't want you making unbonded statements. So don't even try to prove anything because the facts are on the moon. That way now it ain't your burden to prove nothing. It's your job to disprove everything because you're gonna get them opportunity to show their math. If they hand you a document saying you got 24 hours to do this, that, and the other, and you see all these words like we have with these no words like defraud, define. Any word that begins with D and E means no. Even when your lawyer says, I'm going to provide you a defense, get real nervous because a defense means no offense. That's why 98% of the time when you get a lawyer, you lose. That's what you pay for.
Told when a person... I'm sorry. Again. I was just going to say, I was told when a person goes pro se before the appellate court, they normally lose.
They lose on procedure, but they record appealable offenses. The court is there to protect the public. The court is not there to do nothing but that. And if they got to lie, steal, and cheat to protect the public, that's what they're there to do. The word attorney, the root word, the base word of attorney is attorn, which means to turn you over to a third party. So everybody who's a bar member is an attorney. Their job is to turn you over. Get nervous when they're not trying to turn you over because that's what they have a license to do.
Okay.
So don't expect
one last
them
question.
When
the appeal, if the appeal goes through, they'll send it back to the lower court, correct?
When the appeal goes through, they're going to give you merits, and suppose what I would suppose in your situation, without going into the theatrics, is that I want an injunction. You want an injunction. They grant grounds for appeal. They now put it in suspended animation through an injunction. They cease and desist until it's been settled. So until you get paid, the state get paid, the IRS get paid, Santa Claus get paid, and Jesus get paid, it's going to be in a cease and desist standpoint.
So I can request an injunction.
A temporary injunction, right.
Okay. Now, if it does go back to the lower court, if they say, okay, well, we're going to put this back to the lower court, can I request another judge?
Listen to this. It's not about even requesting a judge. Let me be clear. Once you appeal, it's not going back to their backyard for nothing. I'm going to suggest 2 things. When you get this appeal, you put in the mandate that if I am summoned to court, it must be for me to pick up my check. That is the only reason why I'm coming back to talk about any of this BS. because you're holding up my commercial affairs. So
Okay.
you
If
send me
I'm in
something.
court, I'm coming to pick up. I'm sorry.
Right.
If I'm coming to court, I'm coming to get my check.
Right. If you're not providing me a check, then this injunction will become indefinite.
Okay.
So when they contact you, you establish the rules of engagement. It's not about going into their jurisdiction and tap dancing and no.
Okay. Gotcha.
All right.
Thank you,
All right.
sir.
You're welcome. You're welcome.
Thank you.
All right. All right. Okay, we are now 3 minutes into the last hour. So again, please be clear that if you fall out of this class and you want to get back in, you won't be able to in the next 3 minutes. We got 1 more hour that we're going to be able to ask questions. I think I got another person that's got the hand raised, so I'm going to go back. Caller, last digits of your number is 5365. 5365. I'm checking to see if you got any questions, comments, or concerns of anything we covered up until this point.
Well, I did have a question at the moment. I forget what it was. I'm in front of my tablet. I walked away from my notes. But I'm in, though. You can come back to me in a second. I'm got to get my notes back in front of me.
Okay, what I'm going to do then, let everybody get themselves together. I done went down the line and through the list. I'm going to come back. I'm going to ask a few more questions. But keep listening, because if you listen long enough, you'll learn something.
You can't break them. I don't care whether you believe in the Bible or not. You probably find similar versions of this in other writings, but this is the one that seems to have the greatest foundation. So I'm just telling you, the Bible is the best law book ever written. And if you simply follow a few rules, it will protect you, whether you believe it or not. It's like gravity. I drop a pen, it's going to hit the floor. Or I can make an airplane that will defy gravity for a short period of time, but eventually it's got to come down. Okay, these are natural laws. They just work. And this was just, all this did was codify how to get things resolved in ways that prove due process. You want common law? Ask for due process. That is common law. So then I'm going to read on just the last two because I think they're still relevant. Amen, I say to you, whatever you bind on earth shall be bound in heaven. That's a contract, folks. Binding is a signature to promised future performance. So whatever I bind on earth shall be bound in heaven. So in other words, if I do it right in an earthly way, I get the spiritual, I get the law of the universe working for me. Okay? Whatever you loose on earth shall be loosed in heaven. So be careful, if you're going to screw things up, it's probably going to affect you now and forever. Okay? However you interpret this, but to me that's what it means. It's about binding and bonding. Bonds are contracts. Promises to do something. When they put you in jail, they put a bond on you. Again, amen, I say to you, if two of you agree on earth about anything which there are to pray, it shall be granted to them by my heavenly Father. Again, how do you interpret what that means? What does Heavenly Father mean to you? And of course, to Christians, that means to their Lord, right? But what if it also means that Spirit is within you, which is apparently what we were given? Okay? In other words, you'll be at peace, and you'll come to peace. Isn't that what we all want? And then for where two or three are gathered together in my name, I am in the midst of them. So once again, if you're working together with people, maybe the arbitrator is your third person, your second person, your third person, and you're working together for a peaceful conclusion, because that's what this is about. When he's in the midst of you, that's called peace. Isn't that what you want? This is the most important section of the Bible, because it tells us how to fix all our problems. And arbitration, common law arbitration, getting out of their system and doing it through a third party, through private contract, when they also honor private contracts right out of the Constitution first as the priority, then why aren't we doing that? So that's the premise for what we're talking about here. When you skip and you fight, that is to plead guilty or even not guilty, you're fighting, you're giving your grants, you're turning it over to them to decide. That's what you're doing. You've skipped over arbitration. And you think, well, how does that matter to to a criminal matter, again, you have to go to 27 CFR 72.11 and understand that Congress only can authorize commercial act crimes over interstate commerce, and anything that involves commerce can be arbitrated. And we're going to show you a law that also shows that exists. And we're going to show you, again, not maybe all tonight, but some examples of how Congress agrees that arbitration does apply to our commercial matters of all nature. Okay? Tonight I'm not trying to prove it all to you. I'm just trying to give you the 30,000-foot view, but you're going to see more as we put more of the material out and go over it. So I came up with the term myself: conditional acceptance, arbitration, common law arbitration. You're going to find that their contracts always have defects, and all you're doing is pointing out that there are major defects in these contracts, like warrants and search warrants and mortgages. They all have defects. We've talked about how to do that with syntaxing, and that could be incorporated into this as evidence, by the way. But this is just the process to close the deal, okay? So I want you to put it in this context. See, they have the ability to zero the account, and a criminal case is an account as well. They start with a charge, a bill. It's all accounting. And sort of mortgage issues and lawsuits and everything else. So once initiated, the process was not granted upon demand. That is your arbitration process. Once you've established that there is a fact in law, which is contract. A fact in law is contract. You have created a new binding, and I kind of highlighted the word binding, okay? Binding contract with them right out of up here, whenever you bind on earth. And then using the authority you have. So you have the authority we always talk about being a private citizen versus a U.S. citizen or something like that. Yes, we have to act. If we want to be seen as a man, we don't just say it. We don't have to say it. They already know it. But we have to bind it, show them that we understand our procedures, what we have the ability to do, and we have to take charge. So we have to go on offense without going into their courts. And if we do go in their courts, we need to have it already resolved. And that's what we need to do before we begin. We got to get the arbitration step in there and bring it in. That pulls the jurisdiction away from the court. Once they see a contract, and I've seen plenty of case law on this, and again, we'll cover it in future trainings. Once that contract is seen by the court, they'll say, well, we have no jurisdiction at that point because it's already resolved. So we do this conditional acceptance contract type of offer. Then you take them to arbitration. You ask them to zero the account because they have no more claims. And then basically they can do what's called ledger offset credits they created when they opened the account. And if you actually go into the collection, again, I need to get some people to send me their documents, but I haven't looked at some in a while, but I've seen enough others. But when you have a mortgage or a credit card, they'll tell you that how they zero the account and charge it off. Where do they get the money to zero it? Have you ever wondered? Well, this is the way to do what's called a set off. People think you go to the Treasury and you tell them to bring the money over and pay it. No, that's not how it works. You actually have them to take the credit they created when they opened the account, because they created a credit on one side of the account to then issue you the money on the other side of the account. They had to have the credit in place because they have no money. When you read Modern Money Mechanics, you understand they have no money. They have to just create a credit with your signature, your application, and your note. Then they issue the money out of the separate account. Well, guess what? The credit's still there. All we're saying is use the offset credits to settle the account. That's part of the process. It's not the entire process. See, in the system of bankruptcy since 1933, everything has been prepaid to your future promises to perform. You must invoke this, though. In other words, they realize they're out of money, so all they could do is say, well, if people will sign promissory notes, we'll come up with this clever way to put money on account and then lend it back to them. That's all they do. And but the thing is it's already prepaid. You prepaid it you created fictional money out of a fictional document, so pay off the fictional debt. Okay? I'm not saying be irresponsible. I'm saying do the accounting, and you're not being irresponsible. So if the debt is due, they'll zero the account. They'll send you a 1099, making you liable for a tax on it, so they get extra money credit off that. Actually, that's a credit to them. And then they sell off the bad debt again and collect from you again and again and again. Sometimes they send it to 2 or 3 debt collectors. But they've already been paid. The account was zero because the money was already there to pay it. I hope you get this. It's a hard concept. But the credits were created right on the ledger when you sign the contract. The fiction money is made once we sign or answer also a complaint. When we answer a complaint, we say guilty, not guilty, give our name, whatever it is. We've come in and said we'll be liable for this bill that you created. And they have a ledger too in those courts. And everything there is binding. They bond you to 10 years in jail, whatever it is. It's a contract. So let's take some of that insurance money that we created. Essentially, that's what we did, is we insured it with our signature, and use it to settle the accounts, and give them a whole bunch of other reasons to show that whatever contract they've created has major defects, because I wasn't engaged in interstate commerce, so how can this apply, and so on. So again, I already talked about this, how you can kind of zero the balance on a credit account. And by the way, this document, these notes will eventually be put up on the site as well, so you'll be able to read some of this. But here's what we must do. We must conditionally accept their offers. I've been saying this for years, but now we're giving you a very specific roadmap about what to do when they're chasing you. So invoke your right to set it off and create a binding contract for arbitration before they can proceed. And if they have proceeded, to void what they've done. Okay? So if you're dealing with a court matter in their commercial courts, then that's a congressional issue, and Congress says we have a right to arbitration. It's interstate commerce, and there's some level of arbitration rights there because it's a contract when they give it to you. So what we're going to do is we're going to give them a contract as an acceptance. We're going to accept, but give them a contract. Well, we will be happy to settle this matter once you resolve these various issues. One of the contracts you're going to see has almost 400 different sightings. Every single one of them are right out of the law. And all that we're saying is, tell me that it doesn't say that. Tell me that it doesn't say this. And of course, it does say that, right? And if they now agree, which they'll have to by silence, well, then we have a new contract, and our arbitrator is going to settle the matter. Now, let's look at this also from the perspective of the 13th and 14th Amendments. Congress has got to follow these rules, right? Aren't these their rules? Who cares if it applies to you or me? It does apply once a contract is in effect. But if there's no contract or a valid contract, well, then that's our way out. 13th Amendment, Section 1. I'm not going to read all the sections. Neither slavery nor involuntary servitude, except as punishment for a crime whereof a party shall have the duly convicted shall exist within the United States or any other subject to their jurisdiction. Bottom line is involuntary servitude. They can't force you into these contracts. And again, crime is actually a commercial crime under 27 CFR 7211. 13th Amendment, Congress shall have the power to enforce this article through appropriate legislation. And by golly, they did pass appropriate legislation, and it has to do with Article 9, which I'm going to show you a link to. Let's see if I got that link here. Yeah, it's down here. I'll get to it in a minute. 14th Amendment, all persons born or naturalized in the United States. Now, we're not going to talk about that the United States is in the District of Columbia and all that. I want you to see how the contract part works its way in here. All persons born or naturalized in the United States are subject to the jurisdiction thereof, and subject to the jurisdiction thereof, sorry, I'm going too fast, are citizens of the United States. Now, if you've done your research, a citizen of the United States is somebody who lives in the District of Columbia or the territories. But we're not arguing that here yet, okay? Or of the state wherein they reside. And state actually means United States. Anyway, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. So they can't make laws that abridge their immunities and privileges. One of those privileges, folks, is contract. Okay? The state, that means any state, or the United States, cannot create laws that abridge the privileges and immunities of citizens. Contracts create immunities. Privileges are created by contract. You see, you understand what this is saying. So, nor shall any state deprive any person of life, liberty, property, without due process of law, nor deny any person within its jurisdiction equal protection of the laws. And equal protection means if I have a contract and you have a contract, we have to determine who has the real contract. I get equal protection. If there's a contract, such as an arbitration agreement or a right to an arbitration agreement, they cannot interfere with that. And the courts, this can be used in court. Section 14, Section 4, this talks about the validity of the public debt of the United States authorized by law, including debts incurred for payments of pensions, bounties for services in suppressing insurrection or rebellion shall not be questioned. But neither the United States nor any state shall assume or pay the debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, claims shall be held illegal and void. So you can't enslave people. You can't work them into contracts that enslave them, but contracts do matter. And if somebody else works against you, they're committing insurrection and rebellion. So we're going to learn how to use this language to our advantage. Go look up the Commerce Clause. It's under Article 1, Section 8, Clause 3. Write that down. Article 1, Section 8, Clause 3 of the U.S. Constitution gives Congress the power to regulate commerce and with foreign nations and among the several states and with the Indian. Okay? Now, what does this mean? Okay, if you're doing business outside of the District of Columbia, you are foreign. And the several states, which we assume means, again, we haven't looked this up here, but we assume that might mean, in this case, the Union states. But also, you are an estate. You have an estate. It's in your name. It's the all capital letter name. That's how they try to slip it in on you, folks. They call you by the all capitals name. They're presuming that it's under this clause right here. And that's how they pull you in. So we're gonna rebut that. Okay? You have to rebut it. Again, Congress has often used the Commerce Clause to justify exercising legislative power over the activities. This came right off of the website Cornell Law. Congress is just a comment they wrote, but it's interesting they wrote this comment because we all hear about it all day long, and they call you a sovereign citizen for bringing it up, and there it is on their website. Congress has often used the Commerce Clause to justify exercising legislative power over the activity of states and their citizens. Yes, leading to significant and ongoing controversy regarding the balance of power between federal governments and the states.
All right, we're in the final 10 minutes or so. Here's what I'm going to do. Jump into the queue, see who's got any questions. Maybe we all learned something. Caller, last for these of your numbers, 9681. Any other questions pertaining to what you've learned today? 9681. Going once. Going twice. Going down the line. Caller, last for these of your numbers, 7377. Checking in to see if you got any questions, comments, or concerns of anything you learned up until this point today. 7377. Okay, going once, going twice. All right. Caller, last for these are your numbers, 3722. Checking in to see if you got any questions, comments, or concerns or anything you've heard up until this point.
No, I don't have no questions right now, bro.
All right, all right. Try. Last for these of your numbers is going to be 9074. 9074. I'm just see if you got any questions, comments, or concerns or anything you heard up until this point.
Nah, the questions are flowing pretty good, so that the questions I had have been answered by other people. Okay. Thanks.
Cool beans, cool beans. All right. Let's move on down the line. The caller last for these your number is going to be 0199. 0199. Checking in to see if you got any questions, comments, or concerns or anything you heard up until this point.
Not really, but I am kind of curious as to what tax documents do we use regarding the acquisition of a new vehicle for the trust or for the company.
Gotcha. I tell you what, post that inside the Bitrix. I'll make that a priority to bring into the fold. I got quite a few about the various different forms. And before we get into a discussion, it's like everything else. Once you know exactly how you are structured in the transaction, then picking the right form is just a matter of preference. You can do this with a 10.
No, finish what you were saying.
You can do it with a 1099 OID, a 1099C, K1, the 1098F. It's really dependent upon just how swift your broker is. It really depends on just how great of a wealth manager she is.
But would not more so depend on what position the contract is in? Like, I could see if it was something where the 97F, you were getting something out of maybe the surplus from the court, or if the car was in some type of dispute, I could see using it then. So I'm in now.
Keep in mind that if you're in a contract that's honorable and you use that, it's a whole different swag than coming from a dishonor perspective. So I always tell individuals it depends on who you are in the transaction. If you are in honor and you've made your obligations, you're not behind, they're not chasing you, you're not hiding the car at your auntie house, then there's a very painless way of doing this. It's a tax form, but you're dealing with individuals and entities that deal with M3 conveyances and bills of exchanges. Now, doing it with a domestic institution is going to be more or less the Secretary of State providing them the voucher that they need to be compensated, because all vehicles that are being sold, if you go to a dealership, those vehicles on that lot are in trust. They were already paid for when it was manufactured. So you're interacting with a trust. That's why they're trying to get you to 90-day collateralize your own insurance. See, you're making 90 days of payments because debt don't exist until it's been on the book for 90 days. Now, they'll tell you make your monthly payment every month, but technically in corporate aspect, you're making your payment every 90 days. And you're not supposed to be paying fiat. You're supposed to be using tax credit every 90 days.
But doesn't it make more sense that if we're using lawful legal money that we would just go ahead and pay off the vehicle at one time?
If you're paying off the vehicle and not creating more paper, this is what they're looking at. Like, let me tell you where that lies at. Yes, that makes sense, but to play the commercial game, after you get your goodies, you got to play the commerce game. So let me say it a different way. Yes, you can do that.
They want that.
Right. They need, just because you get off the plantation doesn't change the game. They're looking at, are you going to help us create more securities? Yes or no? Because that's going to determine whether you go jail or go home. That's what they're looking at. If you know how to do some stuff, great. If you don't, you're in the way. Now you're a liability. When you actually got an EIN number, you really are a slaveholder. So I try to kind of explain it to students that way. You're a slaveholder. Now, some people who are slaveholders turn their slaves loose. They turn them free. They make them free. Mm-hmm. But some
put them to work.
Right. I'm just saying, is the system is looking at, what are you doing? You got a plantation. Why ain't the cotton being picked?
Okay, so they want to see production. Okay.
Right.
So
it's performance. The insurance don't work if nobody performing.
So then let's go back to what you were saying before. So let's say a person is not in honor. They all jacked up because of society. They're behind their payments. The car's hidden at their cousin's house, the whole nine, right?
Right.
Okay. So then I'm assuming just intellectually that okay, there's a process to basically bring that up to speed and then settle that agreement, and then but at the time
new contract.
The lenders kind of teed off, but is there a way to get into a new situation where you can turn that vehicle and then get another car?
Right. What you do is, remember, you can bring it, push, pull, or trade to another dealer who will finance the old with the new. So there's always a remedy when you are in the business of contracting. Debt is very easy to get into.
So if we get a new purchase agreement and we settle the old, and then incorporate the new, then but it's still the same lender, and then we pay off the new vehicle same way, but we give them the interest payments on top as the sweetener.
You can do that. Technically, if you go more in the asset securitization side of it, it looks like this. The really bad deal that went or muck, you pay some really high insurance, you get it insured. So you got to pay, because it's bad paper, the insurance is higher. But you pay the higher premium. So you get some more, you get some insurance. Now it can be refinanced. Now, remember, the person coming in, you're taking a hit because you got to pay higher insurance. You're paying for the insurance so it can be refinanced. And refinancing is an elegant way of turning bad debt into profitable debt. So it's a way. It's just, how are you contracting? Like, someone who has bad credit can't use their Social Security number, can't use a tax ID number and take advantage of equipment leasing. It's contract. All it is. They will pay off. They'll pay off the old debt. You're able to get new equipment with the stipulation that you're gonna buy more equipment. They're only gonna do this if you're gonna buy equipment. It's not no one hit quitter. I'm not that's not why they effing with you. They rocking with you because you finna perform.
So I guess that kind of almost answers my next question then, because so in the same mindset of, as you say, keep the same energy. So if we're doing refinancing, right, to clean up the bad paper, bringing that up to speed and getting it in the books properly. Right. So if we're presenting an instrument or an asset above the value of the vehicle or the equipment. So let's say the original equipment was $30,000. So now all of a sudden we bring the $30,000 up to speed and we place another $50 on top of it. So now does that mean that we have $50 as a line of credit, or does that mean that they would end up? That
depends on the contracting. Like if this doesn't have certain regulations, you can't do overages. You just pay off the debt and settle it. There's no overages unless there's. It's all about how you contract. Like if it's a government debt, like an example, if it's a government debt, you're just gonna pay it off and keep it moving. There's no extra. Right. If it's a corporation, yeah, they'll get creative. So
I think you answered it when you said it just means you have to buy whatever you're giving them as the overage has to be the new piece of equipment. Right. Okay, that makes more sense.
Right. That's the whole. It's about performance. Insurance only works when people that are performing.
So if we can actually our own, we would still do the same sandwich, and then we can add our own insurance to that too, right?
You need to add your insurance to everything. You go get their insurance and put your own on top of it. It makes a stronger contract.
I don't know if the bank issues that or not. I think they would probably want an outside company. I'll have to ask that question. Because I have a settlement. I got a settlement statement for one of the cars. So I'm trying to go ahead and get that knocked out. But I was thinking about what you were just saying as far as being able to refinance that and then just getting another vehicle through the same lender.
Right. It's just like how they do property. You know, you can use one finance company to refinance, remortgage another. You know, same scenario. It's all it is literally M3 conveyances. Man, we are down to 90 more seconds. Man, I appreciate the questions. I love it. I love it. I love it. Look, guys, keep that energy. Stay tuned. Stay engaged. We will have new content in rotation on 365 Live. So I'm going to bring in some old stuff and some new stuff. Just stay engaged. Remember, as long as you keep doing what you're doing, we're not going anywhere. And with that, I'm going to say peace and love, family. Peace.